Minute file. Bonjour.
Time is flying by. Fabien GELINAS, I'm your moderator for the workshop number 2 on the development of online dispute resolution in quest of an essential public policy. Well, dispute resolution is nothing new. It could
struggle to find its place, even its identity, one might say. Alors, il s'agit en partie.
So it's partially a question of definitions, because you find definitions, very narrow definitions in various contexts, but in other contexts it's a much wider definition, and in particular in the context of Europe. I'll speak English again. I'll try not to switch too often.
More fundamentally, I think we find a tension in the field of ODR between first the private and the public as a matter of initiative, as a matter of funding, and as a matter of transparency. Second, we find a tension between the judicial and the extrajudicial as a matter of deployment sites, and between within and without the court system where we find ODR mechanisms. Third, we find a tension between the adjudicative and the alternative as a matter of dispute resolution modes, whether it promises a decision that is binding and enforceable or a settlement between the parties. I see a fourth tension between efficiency and procedural rights, and this is in our pursuit of access to justice, which we still struggle everywhere to define with any kind of precision. And fifth and last, with the light speed development of AI, and particularly generative AI, we find a tension between regulation and self-regulation, as was discussed earlier this morning. Alors nous avons aujourd'hui.
Today we have the best panel possible in order to enlighten us on these various tensions, and who have experience in this field, with Vincent CALLIPEL from the Cyberjustice Lab of Montreal,
qui est professeur agrégé à l'université.
EINY, Associate Professor at the Faculty of Law, University of Haifa, and Marek Wyszynski, Professor of Law at the Cardinal Stefan Wyszynski University in Warsaw. We'll be hearing 3 presentations, and then we'll have enough time for discussion after having heard our 3 experts. First of all, Valentin, I apologize, Valentin CALLIPEL, and you'll find the biography of our speakers in the documents which were distributed to you. Valentin CALLIPEL is Policy Officer at the Montreal Cyberjustice Laboratory, with over 10 years of experience at the high-tech level of transformation of justice thanks to technology. You have the floor, and you'll be telling us of the public development of ODR in North America, with an accent put on Canada.
Bonjour à tous, je m'exprimerai en français.
Good morning, I'll be speaking French, at least for the well-being. Thank you for welcoming us at this conference, and it's a genuine joy for me to be in this panel with the other participants on the panel. I'd like to introduce to you a certain number of elements which were undertaken as a series of research in Canada, and also I'll be looking into how this work was then undertaken in Canada in general, not just Montreal. Canada is a special model for ODR, online dispute resolution. I'll be summarizing it ODR for my presentation. How was ODR born in Canada? What model settled slowly but surely in Canada? It's a model which you can find, generally speaking, in North America. There are some similar cases in the United States as well. And I'll be introducing a series of initiatives with figures which will make it possible for you to better understand the functioning but also the impact of this type of procedure. And then I'll be putting questions to you. They're still open questions. We still have no answers concerning the future. And in particular, the impact which online dispute resolution might have. And we might have some very interesting prolonged discussion with the other members of the panel on this. So, first element, I'd like to put things back into context because I have the pleasure of starting off the panel. What problems are we talking about? What does ODR try to answer? The problem, first of all, of access to justice. Fabien mentioned the need to have access to justice. Let's put things in perspective in North America. There's a certain typology of dispute which can be best solved with ODR. The dispute of small or medium-sized intensity, which means that they're not complex from the legal point of view. There are no complex issues at hand. For instance, no constitutional issues. And usually there are small amounts at hand and the stakes aren't high. So many small degree conflicts, a debt, small debt, or condominiums, co-ownership in Canada, or belated cases, things which have been for a long time in the realm of justice, still not settled, so unsettled conflicts, but of small amounts, or perhaps also some easier family conflicts or consumer rights. In the field of consumer rights, there can be a lack of balance between the parties. Sometimes there's no knowledge of law or no correct protection. And we also have conflicts with micro companies, very small companies, where there's also no possibility of being represented in court. How can ODR be a solution to these problems? Let's look at definitions. ODR facilitates the integration of information technologies in order to help solve conflicts and disputes. The idea being to offer mechanisms of new process models, as Professor Vernes mentioned, which are quicker, more flexible, in order to physically be absent, but nevertheless be able to be online present at a hearing. ODRs capitalize on alternative modes of dispute settlement, and at the same time there is an intermediary based on technology, knowing that we're not necessarily speaking here of alternative to the classic system. It's a mix of both, but at least it provides for a continuity between the alternative dispute settlement modes and the classic mode. A couple of dates to explain where Canada's at in terms of modernization or of use of ODR. I'll try to be quick on this part. The first international experimentation of use of online platforms was the Cyber Court with arbitration procedures in 1998. the team of Professor Benicleff and other American researchers this time worked on it. Then another series of dates. And you'll see that there's, first of all, the creation of the Cyberjustice Laboratory with Angela and Benicleff. Very interesting idea, since the lab is the result of work which was done with online dispute resolution, and at one point it was highlighted that Internet tools had a genuine potential to solve many conflicts. And the question that was put was, can we reuse what we learned with the Internet in order to facilitate problem solving and conflict solving in front of courts? And the working group 3 of the research project looked at the emergence of new processual models capable of not only using new technology, but also reimagining the judicial procedures and also friendly settlements. The first platform for small amounts was set up. And then there are 2 very important facts. At the international level, 2 jurisdictions directly integrated ODR. 2 Canadian courts, the Civil Resolution Tribunal, and I'll come back to that, and the Condominium Authority Tribunal. So the first one looks at co-ownership and then small sums, but also traffic accidents. And then the Condominium Tribunal, which looks at conflicts between various inhabitants of a co-shared building. And this had an impact on these jurisdictions, because the Justice Bot, and you'll have an idea of what this looks like soon, makes it possible to use enhanced artificial intelligence, and it's actually used by the Quebec judicial authorities. There are a certain amount of elements which make the Canadian model important, because it's a series of initiatives undertaken in order to improve access to justice, the aim being to have a genuine public service. Within partnerships, there's the government, universities, and courts. What you see here is that from one ocean to the other, there are various efforts. Council resolution to the left, and then Nova Scotia on the other side of Canada, online resolution of conflicts linked to family law this time. The Civil Resolution Tribunal, what's important here is that it's an administrative court set up by law, which fully integrates this logic of ODR, using a process which is as follows. There's an oriented pathway. The citizen is informed of his or her rights, explained what his or her role is. There's a file which has to be given to the court, so it's for small amounts, road accidents, management of cooperative companies. Then there's a first step, and that's a negotiation. It's confidential with the 2 parties. A third one with a mediation. If the mediation does not lead to the settlement of the problem between the parties, there will be a decision taken by the court. So there's a logic which is really characteristic of the ODR. There are some 30,000 requests in this oriented pathway of assessment of the rights by the citizens, and at the end of the day there are some 1,500 decisions approximately. There's a friendly settlement of 47%. Friendly settlement rate which is quite high if you compare this to what you traditionally have, at least in Canada. The satisfaction rate is of 91%. Which means that the users are very satisfied with the process. Concerning the technology, there's the Condominium Authority Tribunal in Ontario, which reproduced the same logic. Its specificity is that it was also set up by law, but this time it doesn't have any physical location. The Condominium Authority Tribunal only exists virtually on an online platform. When it's punctually necessary to be in a physical location, then the authority is going to rent a room. 66,000 people in 2022 looked up information on the functioning of their rights in Ontario in co-ownership. 2 million individuals as a total, quite a few who have a condominium. And here also the logic is to try to reduce upstream the number of requests which might go to court, to solve as early as possible and as quickly as possible upcoming conflicts with a 61% solving rate. And then the third project, which I believe is interesting, concerns consumer rights in Quebec. Here we have two specificities. The setting up of a negotiation and mediation procedure for all disputes in the field of consumption in Quebec, with a very high rate of 84% of dispute solving, which means that it's through negotiation that it's solved. The 20% left is mediation, and the satisfaction rate is of 90%, which means that even those who didn't manage to solve the dispute thanks to the platform, nevertheless had the feeling that they were listened to, that they were heard. And one point on which I'd like to attract your attention, Jean-François Roberge undertook research work with a laboratory on the assessment of the feeling of having been heard, the access to justice, sense of access to justice index. This was done with the Consumer Protection Authority, and the result is that one of the few elements you have to assess the quality of justice is the feeling of the users. How did they consider the experience was? Was it a good experience? Was it an efficient experience? And also the feeling of equity, of fairness. It's during the negotiation phase rather than the mediation phase that they feel it. We go from 82 to 96% on this graphic. For a long time, the concern was that if there was no professional in this whole process, it would be worrisome. How could the user consider that justice was being done if there was no professional? But it seems that this concern doesn't actually have that much room. And then in Saskatchewan, a last project, looking into the possibility of using the ODR for road accidents or for violation of the codes. So here too, negotiation, mediation, decision. And here, a reinvention of negotiation. It's called discussion, early resolution discussion. It's a discussion between the Crown, that's how we call the prosecution in Canada, and the driver. So here the user, the driver, is informed of his rights to see if it's possible, for instance, to pay more belatedly, or if the sentence will be lower if he admits the faults from the outset. So what can we learn from the Canadian model? There's a whole variety of different types of disputes which can be handled using ODR, not only consumer rights, but also a public model of ODR which is quite adapted to a whole series of disputes. Even when they reach some emotional intensity, for instance, family disputes or labor disputes, these would be the new types of disputes which could be solved using ODR. So, as a conclusion, we have a continuum here, an arc of resolution. There are two important things. Private platforms didn't find solution or a sustainable model to finance dispute resolution. But what we see is that by structuring a genuine pathway for public ODR, it is doable. And then finally, with the integration of this oriented pathway, tribunals and courts can actually play their role, not only by making decisions, but also by informing. They have a double role. They work upstream by informing the users of their rights. Thank you.
Merci.
Many thanks, Valentin CALLIPEL, for these insights that are the fruit of very enriching initiatives, very diverse initiatives that you followed very closely. And I think that it gives us very enriching insights into the various tensions that we mentioned at the outset.
To my right, to Orna RABINOVICH-EINY. Orna is a law professor at the University of Haifa, as I mentioned earlier. She has worked in the area of ODR for a very long time. She is still very young. She started very early. She has published as a teenager, exactly. She has published widely in the area of ODR and legal procedures in general. One of her books is co-authored with Professor Ethan Catch, who is a pioneer in the area of ODR. He's the one who first had the idea of resolving lists of disputes online. That's the very idea of ODR. That was his. And Orna published a book with him entitled Digital Justice, Technology and the Internet of Disputes at Oxford University Press. She was recently awarded a European Council research grant on the vanishing third party, access to justice, procedural justice, and substantive justice in the age of dispute resolution automation. She's going to talk to us a little bit about the present and then about the future.
Thank you very much for the kind introduction. I'm supposed to have my up here. Oh,
Here we are.
so simple. I control it from here, and where do I control it? Here, just to make it. Just to make it on the entire screen? Do I do it?
It is.
Oh, perfect. Okay, fantastic. So, bonjour. My French teacher would be very cross with me for speaking in English, but I think it's going to be more productive. I'm absolutely delighted to be here. I have to start off by recognizing the amazing work the Cyberjustice Lab has been doing. I'll also share, I'm coming from Israel. It's not an easy time and not an easy day in particular. We're expecting ceasefire to hold and hostages to be released. So I hope I'll be myself, even though I've been a little bit out of things. So thank you so much, Valentin. That was eye-opening, and I think really kind of opens the door for my presentation. And I thought before jumping into what the present state of public ODR is, I should start by talking about what is public ODR, right? In our first session, we talked about what is artificial intelligence. So even if we start talking about what it is, we'll probably find many different opinions, and we should go even a step further and talk about what ODR is, and not only public ODR. And the answer would probably differ according to who we ask and when we ask it. And I want to start with a definition I think we would have proposed probably somewhere in the 90s when ODR started in the e-commerce setting. And we probably would have said something like this, right? A private mechanism that is based on online, that is offered online, is text-based, is the equivalent of familiar processes of ADR that we know that are used to resolve disputes, but in this case applied to online disputes that arose online. And the interesting thing about this definition, as I will show in just a minute, I think every single element of it has been put under question in the past 2.5 decades, right? So we're not talking only about private mechanisms. Not at all. As Valentin has showed us, the arena has shifted almost predominantly to the public arena. We're not only talking about text-based mechanisms. We know what happened in COVID. We know video is very strong. We know, in fact, that now we have many hybrid processes. These are not only the equivalent of familiar ADR processes, but these are actually ways of reimagining justice, right, as we said, and using technology, harnessing technology to thinking about new types of processes that couldn't even exist face-to-face. Automated negotiation, diagnosis, crowd-sourced processes. And they don't have to be alternative. As we saw, they can be part of the formal process in reimagining the journey parties go through. They don't have to be used to resolve disputes. They can be used to making people more knowledgeable about their rights. They can be used for diagnosis. They can even be used for preventing disputes. That's a whole new frontier that we have yet to enter more seriously. And finally, we're not dealing with disputes that arose online. Mainly, we talked about blurring boundaries, but mainly because the boundary between on and offline has really been eroded in the past few decades. It's really difficult to say when a dispute arose online now that we carry around our little machines and we're practically constantly shifting and moving from those arenas. So I would like to offer the following definition. The use of technology in addressing disputes, so not only resolving, addressing, in an attempt to reimagine justice. So we were speaking the same language, and that's good, I think. And this is important, I think, in an attempt to reimagine justice, especially when we talk about public ODR. But I would like to think that not only in the public arena, but perhaps what the public ODR model can do is also be a beacon for the rest of the ODR landscape and also serve as a prism for judges later, maybe when they evaluate private ODR mechanisms. Okay, so all that was a background. And now I'd like to quickly talk about what I see as the two phases of public ODR and just mention briefly the third phase we are currently entering. So the first phase of public ODR was a phase that was premised on written asynchronous processes that were adopted in a group of pioneering courts, and the Canadians, of course, have a place of honor in this list. And they were adopted, I would say, somewhere in the middle of the second decade of the 21st century. So if we were talking before about the mid-late 90s, early 2000s, now we're talking about the sort of 2015s, right? Maybe 14, maybe 16, but that area in pre-COVID. And we see different courts around the world, but also predominantly in North America, adopting ODR. And the interesting thing was they were adopting ODR not for efficiency. Of course, efficiency is always in the background. We think about the backlog and all that. But the driving incentive or motivation was the desire to enhance access to justice. And I stress this because it's important to see how the different phases evolved, and also it's important to remember this as we think of our third phase and where we're headed today. So I'd like to show you just a few slides from research I conducted on one of these processes. It's a platform called Matterhorn, spread in state courts in the U.S., over 150 courts nowadays. It's actually been acquired by Catalyst, so I should say Catalyst, but the research was still performed on Matterhorn. It was performed jointly with Professor J.J. Prescott of Michigan, Professor Avital Mentovich from my own university. And some of the research was performed by Professor Prescott earlier, before we joined forces. And basically, what the Matterhorn case study research allows us, by studying, mind you, online traffic cases, and in certain cases comparing them to face-to-face, but the context here is limited, right? We're talking about traffic. But what we wanted to do was look at different facets of justice, right? So we could fill a whole library and we could argue many, many long weeks about the meaning of justice. But in order to conduct the research and conduct empirical research, we had to choose our metrics for evaluating justice. So we looked at, and some of us looked at, efficiency and access. So access to justice being the one sort of aspect we looked at. The second was to look at outcome fairness, substantive justice, or at least one angle of substantive justice. And the third was looking at procedural justice and legitimacy. And again, I'm reminding you, we're not talking about video. We're talking about asynchronous written communication. So people are not in the courthouse. They're at home. They're communicating when they want to communicate. They can consult with people. And they don't have to face an authority figure in the courtroom. Okay? It comes with its challenges, but it's also something we should bear in mind. So these are findings J.J. Prescott had before we joined forces, and I just think it's really neat to show, and that's why I'm also showing this in terms of thinking about efficiency and its relationship to access. So the longer blue bar is the amount of time it took to resolve cases in courts before Matterhorn was introduced. The short light blue bar is how long online cases took to resolve. And the gray bar is how long offline cases take once the court has adopted the online avenue as well. And I think what's neat about this is you see how not only the online processes are becoming more effective, but also the offline ones, when the judges also have the online avenue occurring in the same court, and we could see how efficiency can be translated into access terms. So we had additional studies really interesting in terms of access, who's using the system at what times, through which equipment, and also on defendants. We talk about access, we often think about plaintiffs, but we should be thinking about defendants as well, and JJ has shown that default judgments have declined with this shift. In terms of outcome fairness, we couldn't, as I said, measure substantive justice broadly, but what we did was tackle a phenomenon that has been a devilish problem, a hard problem to solve, and that's the problem of outcome disparities in courts. Okay, so we know different judges can reach different decisions and have discretion, but what we worry about is when patterns in outcomes are actually follow patterns in demographics. Okay, so we don't want members of specific social groups to be systematically disadvantaged in terms of outcomes. And we know that this phenomenon exists in court, and there is writing on implicit bias and different explanations to why it exists. And it wasn't a surprise. It was replicated in our face-to-face sample in terms of race. But what was interesting to see was that these patterns were eliminated when similar cases were handled through the online medium. And again, I'm reminding, it's a particular design. No pictures of parties, right? Asynchronous written processes. In terms of, so we had one aspect of fairness, right? You might say access is easy, efficiency is easy, we expect them to go up when we move to online processes, but outcomes is interesting, but we want to also tackle procedural fairness because we know, procedural fairness is super important to parties and is important in predicting and shaping legitimacy. But we also know that the main factor influencing a sense of procedural fairness are interpersonal elements. And so our question was, would this translate into the online setting? And we found it did, and that the model worked. We also, and I don't have to go in, time to go into this, so if anyone is interested, I can answer that in the Q&A. We also found that another measure we introduced of perceptions of access to justice was also a predictor of legitimacy. And interestingly enough, it was a stronger predictor for people of low income in shaping their legitimacy of the system. Okay? So all this in terms of the first phase. Second phase, I'll be really quick. Second phase occurred during COVID, right? So we see the launch of these overnight courts have to shift. So you could, adopt some more ODR systems, but this couldn't scale very quickly. And practically overnight, courts adopt video proceedings. And here you see the motivation is very different. And Linda and Anna and I discussed this right before. So obviously during the pandemic, the motivation was first to operate, to exist, right, to survive, maybe efficiency and not get more cases scaled up. And this showed in some cases, let's put it this way, right? So in some cases we found, especially in disempowered parties, that it was very difficult for them to access. Initially, we thought access went up because numbers went up in participation. But once we started looking at what access really meant, effective participation, questions arose because disempowered parties often had, their connections were weaker, they didn't have infrastructure, they were connecting from a small and crowded room, and you could see the pile of laundries and cigarettes behind them, and how that affected not only their procedural experience but also the outcomes, was a question that in many cases we couldn't really examine methodologically. But I should say that earlier studies on video had raised some questions. At the same time, we also saw some Okay, so I'm going to say really quickly. At the same time, we also saw some really promising findings that for some people, in certain contexts, this could work. And the technology also had traits such as equalizing, right, that could work really well and actually empower disempowered parties. So here, I'm just going to say, you could see how the different motivations work for ODR and for remote proceedings. It doesn't mean that they're essentially different, that they have to be about reimagining or about promoting efficiency, right? It's just the way it happened. And we are at a point where we can rethink the motivations and the goals. And I put down that sort of triangle, which I use in my thinking, looking always at access, substantive justice, and procedural justice. I'll say that what we learned was that motivation matters and design matters and context matters. So all this has to be borne in mind when we design new mechanisms. And because context matters and design matters and the motivation matters, research matters, okay? But the challenges that lie ahead have to do with research, even in public entities. We think we could research what's going on. It's very, very difficult to conduct research in courts, and that's a whole different lecture. We see it's difficult to draw the users for interesting. In Canada, some is mandatory, so it's a different issue. But where it's voluntary, it's difficult, and it may not be very different from what we experienced with ADR several decades ago. And I'll just say that the third phase, and maybe the most interesting phase, is still ahead of us with the introduction of AI, right? And we have to ask the same questions. How does it affect access to justice? How does it affect perceptions of fairness? How does it affect substantive justice? Thank you very much. Merci.
Thank you very much, Orna. To go back to your definition, I would propose another definition, which is paraphrasing John Lennon. ODR is what happens while you're busy making other plans.
I like that.
So we turn, without further ado, to Marek Wyszynski, who's a professor at Cardinal Stefan Wyszynski University in Poland. He's an attorney at law and an expert in technology and law. He is an expert to the Council of Europe. He has worked notably with the European Committee on Legal Cooperation, which issued guidelines on online dispute resolution mechanisms in civil and administrative court proceedings. I turn to you.
Good morning, and thank you for inviting me to this conference. And so what should I say after so fantastic presentation, Orna? What you left for me? You know, I'm checking the program in panic, and there is only a point about the failures. And who really wants to speak about the failures? So maybe I will speak about the failures, but let's start with some significant instruments developed by the Council of Europe. We have it. So you can treat it as a kind of the takeaway, as a concluding remarks that you later at home may use, may check these materials. You don't need to Google it, like Yannick suggested before, but you can find it easily on the Council of Europe website. So we have. I'm going to refer to two instruments. On left, you see we have we have ODR guidelines with very extensive explanatory memorandum with examples of the ODR platforms and their impact on the public policy. And then we have They were not created in the legal vacuum. They are based on the existing solutions like Liteko platform in Lithuania, or in Poland we have so-called electronic court systems. So successful platforms operating for a very long time. We can learn from such systems that already build the trust with the user. So the trust is important here. Then our recent project. This is a resource center on cyberjustice and AI. Thank you for this cyberjustice notion from Canada. This is just an excerpt from it. I think that a very good idea of CEPEJ was to present this data in this graphical, friendly visual format. So this could be very useful. It can serve as a basis for comparative studies. A couple of observations about the ODR guidelines. The objective of this document is trying to translate the principles of European Convention on Human Rights into this digital realm with regard to the digital tools. And of particular importance is, of course, Article 6, speaking about access to the court. So exactly as you said, access to the court and how we do understand it, how we interpret it now in the light also of the jurisprudence, this is important. So the assumption, if I remember correctly, was that indeed ODR can enhance access to the courts, provided specific safeguards are in place. So the goal was to provide member states with specific solutions, with the specific safeguards, what needs to be done. You don't need to promote ODRs. The states are just implementing it. So such safeguards are very important now, especially if we think about integration of AI components into the justice system. So this really requires a strong human supervision and transparency. Well, I would confirm that our understanding of ODR in the guidelines is similar to what you presented, Orna, that in fact, by this term, we think about the digital transformation of the courts, and it does not cover arbitration, mediation, or negotiations online. So the member states can only apply indirectly, mutatis mutandis, the guidelines to ADR's mechanisms. Now moving to our latest initiatives, the central idea was to collect the information about digital tools, ODR tools, in one database, up to date, being reviewed, being also checked. Otherwise, the information is scattered. It is challenging to locate it. Now you have it in one place, so it's good, And the request was from the member states. The member states of the Council of Europe requested CEPEJ to create such databases to see what functional systems, what successful platforms are operating in other countries, and what can be used, what can be, well, maybe not copied, but may serve as a source of the inspiration. So we already. The resource center was created just at the beginning of this year, but we were able to collect 92 systems, and we have more than 100 systems in the pipeline, so ready for the review and verification. So no time to discuss all 92 systems, I understand, but maybe just small observation about the category that we call automated ODR. So when the decision is being automated, the judicial decision. Beside Canada, great job Canada, and maybe some initial information about the Chinese systems, we have only 5 private initiatives from France, like Justice School. So maybe some preliminary conclusion from this this work would be that the concept that is now being presented in the media of the robo-judge, of the robo-justice, of the lawyers being replaced by the machine, this is a myth. This is a myth more than reality. It is not proven by the data collected so far. So don't worry, will not be replaced. Of course, another question is about the possible evaluation or assessment of such systems by CEPEJ, and for the time being, CEPEJ does not want to do it. But this, let's say, it would be a natural step that such evaluation will be made, because in my personal opinion, it would align with the expectations from the member states to see the systems that are really, that meets the standards, the principles of the fair trial. So some conclusions, I think that already it was presented in the previous presentation. So we spoke about the efficiency, how to achieve it, about how the ODR enhances the access to the court. By the way, another promotion from my side, let's quote here remote hearings, video conferencing. So this is great tool. And in CEPEJ, we created also separate guidelines on video conferencing, on remote hearings, supported with the good practices from different member states, not only from Europe. Resource Center is mainly on Europe, but sometimes we try to reach beyond that. Lessons from successful platforms and then from the failures. So one lesson maybe from these 2 platforms, from Liteka and eCourt in Poland. In Lithuania, this system operates as of 2005. Quite almost 20 years, and then eCourt operates have been used since 2010. So I think that the main lesson why it is successful, it's not only its user friendliness, but also the fact that the collaboration is needed between the lawyers and IT experts. So you need this. You need this strong collaboration, and also involvement of the judges into the process, into the design of such systems. So we may call it judges by default approach. So the failures now, yes, unfortunately, we have 2 big failures in Europe, one public, one private. We may even call it ODR zombies, because these are the platforms that they try to resurrect it several times. So first is, of course, ODR platform for consumer disputes, created by European Commission, and it is a failure, of course, due to many reasons. Also, traders are not using it, consumers are not aware. You can raise your hand if you are familiar with this platform. If you used it in our practice, probably not. So now the EU is trying to resurrect it, to change it. Yes, I should finish. Yeah. Rechtwijzer is the second example. I don't know if we have someone from Netherlands here with us. Now Rechtwijzer is 40 or something like that. So it was resurrected several times, and of course one of the problems was one of the issues, of course, was lack of the funding. The digital transformation is expensive, it's a challenging process, so they may be right, but people just don't want to use it. Yeah? This is, or was an online platform used for tenant-landlord disputes, divorcing, debts, maybe too many areas, and so this is a failure. So my very provocative lesson from it will be that, you know, you should enhance the core function of the court with the digital tools, not to outsource the justice to external platforms. This is a wrong move, and this is what is our focus also in ODR, in our ODR guidelines. As an attorney at law, I'm particularly happy because this advisor was also presented as a solution for cutting the legal fees of a legal advice, and so it failed, so it's not so easy to reduce the legal fees. Thank you very much. We hope that both ODR guidelines and the Resource Center will help you in your work. Thank you very much.
Thank you. Thank you very much, Marek. I'm hoping to take a question or two from the floor, if there are any. If not, I have one fairly general question that I have for the panelists, and it's the following. If we go back to the basic principle that essentially pushed all of these initiatives, I think, access to justice, what do you answer to the naysayers about ODR who say that what we're doing here is giving more access to less justice? Mm-hmm. So perhaps I'll start with Orna, because I thought there might be the beginning of an answer in the gray bars in the chart that you presented.
Yeah. I think the answer is if we were giving more access and less justice, I would object to adopting it. I think the answer is that many of these statements are based on, I would say some of them are based on data that was not collected in the relevant area. I would say, as I always say in dispute resolution, regardless of whether it is online or not, in dispute resolution you always have to talk about context. You can't provide a general answer that is devoid of context. And therefore, it cannot be that the introduction of technology reduces justice for everyone. It probably, if you introduce it in a certain context, under a certain design, you could potentially enhance both access and justice, and maybe in other areas you would detract from it. So let me give an example. For example, even technology that didn't require too much design, like video conferencing, right? So when it was employed in the U.S. in landlord-tenant cases as is, it resulted in very problematic circumstances because many of the tenants couldn't even attend. Those who couldn't pay rent, many times their phone was cut off. Okay, so they didn't even have a way to connect to these proceedings. And that was very problematic, and they didn't get access and they didn't get justice. Or those who did get access might not have gotten justice. In another context, which Ayala presented at your conference a while back, we studied in Israel a business setting in which video, text, and in some cases video proceedings were used in appeals on tax authorities' decision to grant COVID-related compensation. Video worked amazingly well. Okay, and maybe it's not amazing. These were businesses, but some of them small businesses, right? Someone doing massage at home or, not necessarily huge, sophisticated businesses. And there, this worked extremely well. Not only did it work well, we found that video was critical as an addition to the written, I would say it wasn't an ODR process, it was document-based process. But video added another layer of trust and neutrality. Okay, so that was really important. So context is everything. I wouldn't make a general statement.
So I take it here that I might come from a very lawyerly perspective and see justice defined as something that is very procedural, very lawyerly, as opposed to what the justiciable might think about it. And that reminds me of the index of the sense of access to justice that you talked about, Valentin.
Alors,
Yes. To continue along that line, it's very important to understand what criticisms there is from the naysayers against ODR. Perhaps it's a technical solution to say that simply by integrating technology, we might be able to totally transform the functioning of justice and change it totally from A to Z. So I think one thing you have to oppose to that is that that's actually anti-lawyers saying that type of thing. These types of platforms cannot be a substitution to a lawyer, to individual representation. You can't have less equity, less representation of the rights. So it's a neoliberal way of saying, no, let's stop access to courts and instead let's invest in technologies. So this type of criticism is interesting, yes, but it doesn't take into consideration the models which are developed for public ODR, where obviously it isn't just one method, it's a whole arc of resolution. There's first information far upstream before any decision, information as to the rights and the position of the judge. The role of the judge is somewhere midstream. After having informed the parties of their rights and obligations, and to come back to what Orna was saying, there's no standardization. It's not just copy-paste or copy and paste. If it worked in Canada, it doesn't mean it will work elsewhere. It's not because it works in one field, someplace that it will work in other fields, even in the same place. Any mechanism aiming at finding a solution to a conflict has to find its place in the context, the country and the dispute.
Referred to essentially the idea of subcontracting justice, something that was described as not the way forward. Perhaps you can relate this to access to justice.
But if I may first answer to your first question about more access, less justice. Yes. So there is this old Jewish proverb, it's better to be young, rich and healthy than old, poor and sick. So you can have both, yes? So you can have more access and more justice. Probably, maybe because if you implement in a correct way the AI mechanism, it will reduce the administrative burden on the judges, and they will have more time to really make the justice. About subcontracting, of course you need some subcontractors, but also you have to build the methodology, how you want to do it. So that's why I think that with having such tools like ODR guidelines, then you can present it as this basis for this methodology for the subcontractors, how it should look like, how the design of the system should be done. Thank you.
Thank you very much.
Two concepts I would like us to put in the discussion.
You said one.
Okay, one. Online, I would say process pluralism. So we should remember it's not just online. We can also have processes that are mixed and hybrid.
Well, most enlightening. I'm afraid we've overstepped our time by about 4 minutes, so we've come to the end. I'm asked to make an announcement concerning the what comes after lunch. I think we'll move now to our lunch in the same area, if I understand correctly. And after the lunch break will end at 2 p.m. And we'll all go to a plenary in room G3, the room that we used this morning earlier. So 2 o'clock, be there on time. We have a roundtable moderated by Emmanuel Netter. So it remains for me to ask you all to join me in thanking our panelists for what I thought was a very enlightening discussion. Thank you.
to say and I wanted to say, but I think it's an important point, is that what technology introduces also is the